All right, this is case number SE 19240-893. This is Starlene Bragg versus Ardina R. Hendrick. The matter is before the court on adjourned date regarding a proof of a bankruptcy discharge. This matter was before me just a couple of days ago, and I sent it over because the defendant in this matter has received an order of discharge from bankruptcy, and the question was whether or not the plaintiff was listed, the debtor, the creditor was listed as a on the bankruptcy. Do I have with me today Starlene Bragg? Ms. Bragg, do I have with me Ms. Hendrick? All right, I see Ms. Hendrick there. Good morning to you, Ms. Hendrick. All right, we'll come back to this matter. I thought I could resolve that rather quickly. Are we, we're not on mute or anything, are we? No. All right, the court now calls case number 22-19291, Portfolio Recovery Associates LLC versus Lorraine Reed. The matter is before the court on the filing of a motion for summary disposition. The record should reflect that the court did receive a one-page document that is reported as an answer to this matter back in October. And then I set the matter over for a hearing on today's date. All right, counsel, your appearance for portfolio, please.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722. How are you?
I'm good, sir. Good morning to you. Lorraine Reed is who I'm looking for now. Ms. Reed, if you're on the Zoom, that's Lorann, last name Reed. If you're on the Zoom, please say something at this time. The record should reflect that the court did send out a notice of hearing regarding this date. And that notice of hearing is to the address provided by Ms. Reed on Strasburg. That's the answer that was attached to her answer. Counsel, have you had any contact with Ms. Reed?
We have not, Your Honor.
All right, so it looks like she has not appeared for this hearing. It was set for 9:30. It is now 13 minutes after 10. So tell me about your motion for summary disposition, counsel.
Yes, Your Honor. It's a C9, C10 motion. It's a credit card debt that was assigned to my client. We provided statements showing use of the account. We provided an affidavit as the amount due and owing, as well as the assignment paperwork. Defendant's answer indicates that he didn't enter into a contract with Portfolio Recovery, which again, it was an assigned debt. I don't believe there's been a valid defense or a genuine issue of fact provided. There's been no response to the motion pursuant to the court rule. So I would ask that the motion be granted and the judgment enter today.
All right. There has not been a response to the motion. The court has reviewed the answer provided in this matter. And when I take all those things into consideration, it does not appear that there is a genuine issue of material fact, nor has there been a valid defense raised to the claim. And for those reasons, the court will grant the motion for summary disposition in this matter, and will enter judgment on the granting of the motion. And so, counsel, you can submit an order to the court, and I will sign it.
Will do, Your Honor. I'm just checking. I want to make sure there wasn't an order already in the motion. Sometimes there is.
Now, let me take a look at it. While you're looking
It would. Let's see.
I didn't see one, but I'm looking again. Oh, yeah, I do see one.
Yep. Yeah, perfect.
Look rather quickly here. Let me take a look for a moment. All right, I'll go ahead and grant judgment. I'll sign that order, counsel. I already have order that is sufficient in this matter.
Thanks, Judge. Have a wonderful day.
And likewise. One moment. All right, this is case number 22194794. This is Hidden Valley Apartments LLC versus Christina Dunn. The matter is before the court after having received the answer of the defendant in this matter. The court has also received a motion for summary disposition regarding this matter. Your appearance for Hidden Valley, please.
Good morning, Your Honor. Now Jack Francis, C72322 on behalf of plaintiff's attorney of record.
Thank you, Ms. Francis. Good morning to you. Christina Dunn, do I have Ms. Dunn on this record? Say something if you're here, ma'am.
Yes, I'm here.
To you, Ms. Dunn. Ms. Dunn, there is a motion that's been filed for the court to decide this case on the motion. You received a copy of that motion, ma'am?
Yes, I did. It's right here.
And I know that you did not file a written response to it.
I did file a written response. I took it down to the 36th District Court and she gave me papers. Can I grab that really fast? It's right here.
So when did you file the written response to the motion?
I would have to look at the paper. I don't remember the date.
Okay, now I know that you filed an answer, and you filed an answer with the court on the 25th of October. Are you saying
Okay.
You filed something after that?
No, I didn't. That is the response.
Okay, all right, but the motion for summary disposition is a different document. Your answer was a response to the complaint. So the motion for summary disposition was filed in November. Let me hear what plaintiff's counsel has to say about this matter.
Yes, Your Honor, we did not receive a response either. We would like to proceed with our motion for summary disposition today. Is that what you wanted me to do now?
Right. So tell me what your motion is about for the record, if you will. I know this involves a claim of a looks like debt that's in the nature of $6,400. Tell me why you believe the plaintiff is entitled to judgment at this time.
Yes, Your Honor. This was pursuant to a residential lease agreement that was entered by the parties, Hidden Valley Apartments and the defendant, Christina Dunn. The defendant was eventually evicted from the premises for non-payment. We did attach a copy of that judgment to our motion as Exhibit 3.
Judge, I hear about a
and
lot of
then
interference.
1 second, yeah. It's kind of cloudy, so let me change something here. So, Ms. Dunn, if you will, I'm going to mute you so that I don't hear the noise in your background for just a moment here. Okay, and let's try again, Ms. Francis. You were saying that this was a residential lease agreement, and the claim is that this was regarding to Hidden Valley Apartments, unit number 710.
Yes, Your Honor. And then defendant was evicted from the premises for non-payment of rent. We attached that judgment as Exhibit 3 to our motion. And then Exhibit 2 has the itemized list for the security deposit refund, which shows all of the damages we are now seeking. There were some damages to the property. There were utility bills that were unpaid. There was the rent from the possession judgment that we received. Then there were costs for having the writ and the bailiff. And then there were subsequent rent for the remaining portion of the lease. And then we did deduct the security deposit from that amount. And then since then, there has also been interest that has accrued under MCL 438.31. And that's how we've come up with the $6,404.69.
Great. So I'm looking at your security deposit refund item, and you list there as a lease default February through April, this was a period where the defendant was no longer residing in the present, in the residence, is that correct?
I believe so, Your Honor. It was the remainder of the term of the lease where we were not able to re-rent the property until it was re-rented.
Yeah, and that's you kind of answered my second question. I see at the lower part of the document, and it indicates it was re-rented on 4/14, correct?
Correct, Your Honor.
Just one moment. How long, do you have any information, Madam Counsel, as to how long the tenant resided in the property?
The lease was from March 24th of 2016. So through January of 2017.
All right, so she had only been there for several months. There was not years before or anything. You're saying that she only resided in the property. I'm sorry.
Correct.
Okay. All right, thank you, Counsel. All right, Miss Dunn, I'm going to allow you to come off mute. There you go.
Okay.
All right, so you lived at this property in 2017, is that correct, ma'am?
I didn't live there, but I signed a lease agreement for someone else to live there. Yes.
Okay. All right. So did you ever live at this property at any
No.
point? Okay.
No.
So 2017 was the only time that you had engagement here in terms of signing a lease and so on and so forth, correct?
Yes.
So tell me what your objection is to the motion in this matter, because what they're saying, number one, there was a judgment entered by another court that allowed that person to be evicted from the property. And then they calculated what the damages were to the property, carpet and things like that. And then because there was a lease agreement, they're able to continue collecting rent even after the person is evicted because of the lease agreement. Talk to me about this.
Well, as I stated before, I wasn't living in the property. I got it for someone else, which I know isn't good. I was young, trying to help someone, and I got screwed. So now I'm here. I showed up because I didn't do anything wrong. I didn't try to take anything from Hidden Valley. I just thought I could trust the person that I did that for, but I couldn't. So now I'm in a position of trying to figure out how can I move forward, because I really feel like I was taken advantage of, but that's neither here nor there, you know?
All right. So you do have, obviously you have the right to go after that person that was living there that didn't do what they were supposed to do to try and recoup some of this. Let me ask you, Ms. Francis, have the two of you talked about trying to see if there is some number that you could settle this case on?
We tried to go into a breakout room earlier, Your Honor, but we weren't able to.
Well, let me put you in a breakout room for a moment, because there is some liability here. Maybe you can arrive at something by way of a settlement, reduce the amount and so on and so forth. Try to do that anyway. And then I'll come back and I'll make whatever determination I can make, but hopefully you can get it worked out by talking about it. So I'm sending you a notification. Go ahead to the breakout room and then I'll be back. I'll be here when you come back.
And Judge, I have one other matter as well for 806.
Which one is it? What's the last three digits?
806.
Okay. 1 second before you leave, Mr. Francis. Do I have Giles, last name Giles? And Miss Christina, just one moment, ma'am, before I send you to the breakout room. All right, so this is case number 22-185-806, Universal Collections versus Andrea Giles. The matter is before the court, where the court previously granted a motion for summary disposition in this regard. Apparently it got reset. All right, so Madam Counsel, your appearance at this time.
Naljat Francis on behalf of plaintiff's attorney record.
All right, thank you, counsel. And state your name for the record, Ms. Giles, please.
Good morning. My name is Audrey Giles.
All right, thank you, Ms. Giles. Update me at this time, Ms. Francis.
Your Honor, this was set for today as you awarded a portion of our damages at the last hearing and set it for further hearing as Ms. Giles wanted another copy of the motion for summary disposition and for her to respond to it as to the remainder of the damages. Your Honor, we have not yet received any response from Ms. Giles as to our motion for summary disposition.
Okay, and I don't have the record in front of me. I know that the judgment that I granted indicates the judgment I granted on November 28, 2022. It says that the court is therefore ordered that the motion for summary disposition is granted as to liability as to partial damages in the amount of $3,557, where there is no genuine dispute as to material issues, except as to the amount of damages. So there was some dispute regarding the difference in the amount that was granted in the judgment. Can you update me on that, Ms. Giles, as to what the dispute was regarding the other damages?
Yes, sir. My dispute was that they were claiming that I destroyed their home. They were claiming that they needed to replace a kitchen, walls, floors, things that was wrong with the property when I first purchased the property. And my dispute is, if I purchased it in that way, and why am I being charged for the conditions of the home when I purchased it? I didn't cause those damages. I purchased the home in it. So it's like they want me to pay for something I didn't do. They want me to, well, I'm not sure, but it's as if they was expecting me to fix their house up completely. And because I didn't do it in their time, and they're saying that I should pay for it. But I purchased the house in that condition. That house had no floors. The walls was in terrible, the house was it was dilapidated. The house was in horrible conditions. Horrible.
So you never lived in the property, correct?
I didn't have a chance. No, I tried to fix it up though. I did my best in the time that I was given, as well as I was paying what I was due to pay, the $725 a month. I took on too much. It was a big bite. And I had no idea the conditions of the home. When I knew it had a horrible smell, but I'm a great cleaner. I figured I can clean that up and just keep it going. No, sir. I discovered that house was infested with like 6 feet rats. It was infested with roaches. The little cosmetic things that they're saying that I endorse. I had to fix the doors. The house was wide open. There were no doors, but they're in their report claim, they're saying that I owe for doors as well. Those doors were that way. Those floors was that way. Those walls was that way. That kitchen was that way. If anything, I did a lot in the 11 months that I was there. So much so that when I was evicted on the 12th of February, they had another person living in that house by March 1st. So that house couldn't have been in that bad of a shape. If it was, that's how they're selling. That's what I think. It's some type of, they're being false with their information. I'm sorry, I'm saying a mouthful, but forgive me.
Ms. Giles, Ms. Giles, let me have you raise your right hand to be sworn at this time. You do solemnly swear or affirm that the statement that you've given to me on this record today, that those statements are so help me God?
Yes, I do.
And again, you said you moved there. It was a wide open place. You made some repairs, but many that you didn't get around to, and the condition relative to the floors and the things that are being complained, like you said, that those are things that were pre-existing. You didn't create those problems, correct?
That is correct. I did not.
Okay, you can put your hand down at this time. Ms. Francis, any inquiry you want to make of Ms. Giles before you make your arguments?
Your Honor, she testified that she didn't live there. However, the lease before she was evicted, as she also stated, was 11 months she was there. So for 11 months, she's claiming that there were no doors on the property, um, and things of that nature. Your Honor, I just don't think that's possible. We have so
Ms.
many
Francis,
damages. The
Ms.
point,
Francis, let me stop you. I believe the testimony is that she had possession of the property for 11 months, that she never lived there. That during that period of time, she was in the process of making some repairs. And she did testify there at the end that the month after she lost control of the property, that someone else was living in the property. That seems to be the nature of the testimony here. Go ahead, Counsel. I interrupted you there because I wanted to make sure that that the testimony that I heard, I was very clear about what I heard on this record. Go ahead, Counsel.
and Your Honor, parts of the damages that we claimed are, it was all repaired. So that's the reason we had to spend the money to repair. Your Honor, could we mute Ms. Giles? I'm not sure if you can really hear me.
I'm hearing you okay. It's a little bit cloudy. I don't know if it's your device or I'm not sure what is going on, but I think I'm hearing you clear enough. You may continue.
Okay. Your Honor, we had to repaint, we had to fix the doors, we had to fix the floors, and we had to fix the kitchen completely. We had to clean out debris out of the house. And then we had to contact an exterminator and have the property exterminated. These are all things that we had to pay for to be able to bring a new tenant into the property. And that's all attached as our exhibit 3.
I hate to interrupt for a moment. Ms. Giles, nobody distracted you while you were testifying?
Oh, was that a distraction? My apologies. I didn't want to talk over her. Forgive me, ma'am. Forgive me, sir.
I don't conduct court by raising hands and stuff. I allow you to talk, and then she talks, and if you have something else to say, I'm going to come back to you. So raising hands and stuff, you don't have to do all of that. Go ahead, Ms. Francis. I'm sorry for the interruption.
Thank you, Judge. We've attached all of those damages as our exhibit 3 to our motion. Ms. Giles has only provided, she has not provided any proof to overcome our motion for summary disposition. We've provided our proof showing that we had to pay for these damages to repair the property. If she's claiming that it was a pre-existing condition, then she should provide her proof, pictures of the property before she moved in. She has not provided any documents. It's just stating that this is the condition it was in and that's the condition she left it in, which is not true. She's stating she attempted to make repairs. I don't know if those repairs were successful or if it made the property worse. But Your Honor, that would be her burden to provide proof that this is the condition that the property was in before she moved in. So at this point, she has not gone over the burden of her burden of motion for summary disposition, as we did file a motion under C9 and C10, Your Honor. So I would ask for our motion to be granted on the remaining portion of the damages.
All right, Counsel, let me ask you. There's nothing. Well, I should say first of all, this agreement was entered into by the parties herein that are now dealing with this, the after effects of this, and it was a purchase contract. Is that correct?
This is a purchase, assigned debt, Your Honor.
Yeah, and I guess what my concern is that the plaintiff in this matter knew of the conditions that it sold the property or intended to sell the property, but they're only reflecting by way of their motion on the conditions when they recovered the property. So I think that there is a relationship between what the property condition was before Mr. Giles purchased it, and then when it was repossessed, what the condition was. There is no allegation here setting forth that the property was in proper state of repair at the time that it was sold. Let me, Ms. Giles.
Yes, sir.
You told me by way of your testimony that the property was in a substantial state of disrepair at the time that you engaged in the purchase, correct?
That is correct.
What was different about the property at the time that it was taken back by, Universal? What was different about
I actually submitted photos to the court. I actually did.
it? Stop, I didn't ask you that. I didn't ask you that.
Oh, I'm sorry.
I want you to tell me.
What I repaired was the bathroom. There was no bathroom sink there. I repaired the entire, because I'm a lady. I repaired the bathroom. I painted the entire kitchen. I repaired the side door and the front door because it wouldn't close. I even sent in video of me fixing that side door. It was a big bite. I didn't get it was already, I purchased all the wood. I purchased everything that was going to go on the floor because there was no floor. That's what they removed. That wasn't debris. That was actually the materials for the home. I repaired a back wall. The back wall there, it was completely, I submitted a photo of the back room. There's a back room to the left of the home. And then the back wall, there was yellow, I don't know, some type of yellow foam stuff holding the window together. And at the bottom, you can see the back of the wall. You can see the, I want to say the brick. I repaired that big hole. I put in windows. There was no window in that room. There was no window in the other room. I repaired that window. In the other room, not to mention how I cleaned the home. I exterminated the home. The home actually had, like I said, it was rats. I exterminated those rats. I filled in rat holes. What is that called? That's the first thing I did. I want to say the gutter, or I had to rent a what is that called when you snake? I had to rent a snake from Home Depot, an industrial snake, because the prior person, I'm assuming, they filled the tank, they filled the floors up with white paint. So if you ran water in the bathroom, there was no sink in the kitchen, but if you ran water in a bathtub, it would stop up because the drains were filled with white paint. I had that. I did that. The house was leaking. Because during this time it was winter time. It was leaking. I repaired the outside of it. What is that called? When the foundation is leaking into the basement, because the basement was, if it rained or the snow melted, it would come down. I repaired that. I was trying to make it where it would be livable. I did the best I could, but I did not destroy that home. And I did submit papers and videos to the court of the home in the condition that I am speaking of. I really did.
Thank you, Ms. Giles. Last word on this, on the motion, Madam Council.
Your Honor, again, I have not seen any videos or pictures that the defendant has submitted to the court. So I'm not, so again, I just have her testimony that these are pre-existing conditions. But once again, for a motion for summary disposition, you have to provide actual proof to overcome the burden of a motion for summary disposition. If there are additional proofs that she has provided, I would ask for her to also provide those to plaintiffs so that we can see them as well.
I can do that.
I really didn't come to you then, but
oh, forgive me.
Oh, we did. All right. All right. I've heard the motion for summary disposition in this matter. The defendant has offered by way of testimony on the record, as well as submission of other documents, and moreover, the plaintiff has not established by way of its complaint what the conditions were on the property. So the defendant in this matter seems to be in the best position to describe that by way of testimony, and she has done so. And the significant thing that she's indicated by way of her testimony, which is evidence now in this case, is that the conditions that were complained of by the plaintiff as it relates to the property once the property was repossessed were conditions that existed before the property was reportedly sold to Ms. Giles. That she did some improvements, but conditions that were there before, those conditions persisted, and she was not able to complete what she desired to do before the property was taken back. It would seem then that the additional damages beyond what has been granted in the motion for summary disposition would be an effort to require that the defendant do things that are beyond what her responsibility was. The property was not in the state of repair at the time that it was rented or at the time that it was sold. And when recovered, it was in the same or better condition that it was at the time that the property was sold. The plaintiff should not be able to receive amounts that would aid them in bringing the property to a greater position than what it was at the time that they sold it and at the time that they recovered it in that same condition. For that reason, the motion for summary disposition on the additional damages issue, that the motion for the additional damages will be denied as the court finds that the proofs in that regard are insufficient. All right, now, so where that leaves the case now is that we've had something of a trial on those issues, but it has not been formally set as a trial. Madam Counsel, that is my configuration of what this case looks like. If you want me to set it up for a trial on those issues, then I'll do it.
I'm sorry, I didn't hear the last part, Your Honor.
Oh, yeah, I was saying, if you want me to set it for a trial, we'll rehash the issues of what it looked like before and what it looked like after, because that on this record, the testimony that I've heard would tend to show that the property was recovered in a condition that the same condition that it was in or better before it was sold to Ms. Giles, that she did not make the property worse based upon the testimony and evidence that I've received so far. So that denies that part of the motion for summary disposition. The issue of liability on some of this has already been decided, but the question becomes a question of damages, and I don't see where Ms. Giles damaged the property in the way that the plaintiff is claiming.
Your Honor, at this time, I would just move to dismiss the remainder of our complaint without prejudice.
All right, that sounds like the right way to deal with this at this time, and that is a dismissal without prejudice. If the plaintiff decided that they wanted to pursue those issues, they still could reinstate and try to go after those issues. I just, after hearing the testimony, I don't see where there is a basis for the additional damages, and that doesn't mean that there's not. What it means is that on this record, the plaintiff is not able to preponderate. If I'm looking at this as even hands before me, the plaintiff has the duty here and really to tilt the scale. And there's not enough here to establish that Ms. Giles made the property worse. That's the bottom line. All right. Good day to you. All right.
Thank you, Your Honor.
Thank you.
If I could go into the breakout room with Ms. Dunn.
I didn't hear you, Ms. Francis, that time. What did you say, ma'am?
I still needed to go into the breakout room with Ms. Dunn.
Yeah. Very well. Go ahead and Ms. Dunn, if you're not already there, you can go to the breakout room.
I'm waiting for the.
I sent you a notification. You didn't get it?
No.
Okay, I'm going to send you another one. But when I send you this one, don't go there. I'm going to send you the two, and then I'm going to flip you back to one.
Okay.
Ms. Francis, did you get the notification?
I did not, Your Honor.
Oh, wait a minute. Okay, something is. I see the problem. Just 1 second.
I got one now.
All right, Ms. Dunn, you have the notification? Okay. All right. right, this is a recall on SC 19240893. This is Starlene Bragg versus Ardina Hendrick. If either of those persons are on the Zoom, please say something at this time.
I'm here, Your Honor. Ms. Hendricks, I'm here.
All right, thank you, Ms. Hendricks. Ms. Hendricks, did you have a copy of the discharge in this matter?
Yes, sir. I brought it down to the court and I submitted it down on the second floor. Actually, I came up to the fifth floor, but everyone was gone. So I went back down to the second floor and I submitted the papers that you asked me for.
When did you do that, ma'am?
Pardon me?
Yeah, when did you do that?
You can take me down there Tuesday. Yesterday, sir.
Okay, all right. Let me see if I can get, I think, is there a way that we can try that paper? Case number is 19240893. Just be quiet, Ms. Hendricks, for a moment.
Mm.
She said she dropped some papers off on the second floor. I wanted them in the courtroom. She said by the time she got it.
What did she file?
She was supposed to submit a discharge concerning her bankruptcy, so I can see whether or not this Bragg was discharged. I probably need to get that in my hands, right? We're looking to see if we have the paperwork here. All right, now while Ms. Hendricks is waiting, why do I have Larry Wilson on this Zoom, Mr. Wilson?
Yes,
Yeah, why are you here, sir?
I'm here on behalf of Sean Taylor. I'm his brother,
Who?
Sean Taylor.
Yeah, I don't have a case with Sean Taylor. What's the case number? What type of case is it, first of all?
It's a eviction case for an auto repair business.
So someone is being evicted, or are they trying to evict someone?
Trying to evict. Case. You want the case number?
Yeah, that's not in front of me, because this is a civil courtroom. This is not landlord tenant. So let's find out where you're supposed to be.
223-75271.
You're supposed to be in courtroom 436.
You're supposed to be in courtroom 436. This is 336, so you want to back out and dial 360-436-0000.
Okay, courtroom 436. Okay, thank you.
All right, I wish you welcome.
I'll go down here and see if they can.
Thank you, Madam Clerk. I'm looking now at Gary Taylor. Say something. Why are you here? Oh, Mr. Taylor, you were with the other gentleman, correct? Okay, I'm looking for Crystal now. The phone in the case, or the device in the case. Crystal, who is that?
Right here. Hold on 1 second. I gotta turn the video on. Hello.
Hey, how are you?
Good. How you doing?
Good. Why are you here, ma'am?
I have a bench trial. Premier Real Estate versus Crystal Griffin Cleary. It was supposed to be a bench trial today, 10:30 on the 12th. That's what it said on this paper, anyway.
Let's see. Let me see my paper here. What judge does it tell you is in front of?
It said Donald Coleman. I remember you.
It's not on my calendar today.
I'm gonna look at the register of actions, but it did say the 12th today at 10:30 in front of you.
I don't have it filed in front of me, so.
Oh, you want the case number?
No, because my clerk is not here right now. Madam Reporter, you know anything about this?
It doesn't sound familiar. What's your last name, Crystal?
Griffin Cleary
Versus?
versus Premier Real Estate.
Don't
No,
sound,
they're still me.
doesn't sound familiar at all.
Okay. Yeah, it says bench trial schedule 1/12/23, and the case called both parties at 10:30 a.m. in front of Judge Donald Coleman.
All right, so when my clerk comes back, we'll check on that one.
Okay. Judge Coleman.
Yeah.
Okay, they may have my last name spelled wrong in that register of actions. It says clearly, Clearly. That's not my last. That's not how you spell my last name. So.
Doesn't matter. The case number is what's important.
Oh, okay.
The lady says it's a matter of set of trial. What's your case number, ma'am?
221
221.
84852.
I'm sorry.
That's the Judge Lisa Jones Coleman courtroom.
Yeah, that's not my case. You should be in front of Judge Lisa Jones. That courtroom is you had to dial 534 instead of 336.
Oh, I thought I was in through 534 already. Okay. This is, yeah, you said who's it now?
The direction, the issue that you're having with the Zoom numbers, that's not your problem. That's because my courtroom was 336. They changed it to 534. but they kept me with the Zoom number 336. So it's not your mix-up. So you have to do the Zoom 534, and that should take you to Jones Coleman, correct, Madam Clerk?
Yeah.
All right. So 360-534, 0000, and that will take you to Alicia Jones Coleman.
Okay, you said Alicia Jones Coleman. Okay,
Yes, ma'am.
thank you.
All right. And on the record, with regard to the suffix 0893, I have received a document that was submitted by Ms. Hendrick. And Ms. Hendrick, I'm taking a look at that right now. Ms. Francis and Ms. Dunn, I'll right with you in just a moment. And I do see listed on the document from probate, excuse me, from the federal bankruptcy court, I do see that the debt as to Ms. Ardina, that the debt as to Ms. Bragg, looks like that debt was listed in this case number as a lawsuit and involved the creditor, Starlene Bragg. And it also makes reference to the debt occurring. I'm just looking at some of the information. It makes reference to this particular case number, the suffix of 0893. It also makes reference to the date and time when this matter might have arose. So it appears to me from the documents that I've reviewed, it also makes reference to the amount as $5,000. And in this case, the defendant was sued on a debt for a moment here. For $5,000. So the claims appear to be the same, and the defendant was in fact granted a discharge in bankruptcy, and the court then find that this matter is closed, where the debt has been discharged in bankruptcy. So ordered. Now, ma'am, it looks like Ms. Hendricks, it looks like you gave me the original copies of your documents. Did you keep copies of this or no?
Yes, they are the originals.
Well, you didn't make a copy?
Yes, the clerk, when I come in, I guess it was close to time for them to go home, and she just went through, made copies, and I told her where it was supposed to go, and she handed me back these and kept those.
Okay, she gave you back some copies, all right? That's what I'm talking about.
Yeah.
Okay, so
Yes,
you're all set. You're all set.
I'm all done.
Now, this case is closed, ma'am.
Thank you, sir.
All right, good day to you.
You too. Thank you.
And back on the record in Hidden Valley versus Christina Dunn. And at the direction of the court, the parties did go to a breakout room to try and talk about this a bit. Go ahead and update me, Ms. Francis, at this time.
Thank you, Judge. We did agree to a consent judgment, Your Honor. The damages are $6,404.69 plus costs and statutory attorney fee for a total judgment of $6,629.27. Ms. Dunn, do we have your permission to sign the consent judgment to submit it to the court?
Yes.
Thank you.
Right, so it looks like the agreement was just as to the judgment. Did you all talk about any reductions of any amounts? Did you try to get a lower amount on this or make a pitch for something lower, Ms. Dunn?
No,
No,
Your Honor,
full amount. We want the full 6,600.
Ms. Francis, you didn't have any power to compromise on some of this, given the
No, Your
circumstances?
Honor, I did not. We did discuss a payment plan, so I am going to take that back to my client to see if we can work out a payment plan.
All right. So how are you planning on taking care of this, Ms. Dunn?
The payment plan, I guess monthly. I don't even have the money to give them, but I will lose my house trying to pay them.
All right. All right, I will sign the judgment upon presentment, ma'am. If, when it comes to paying this, ma'am, I know that you're trying to reach an agreement for a monthly payment. You always have the right to file a petition for installment payments. That is for the court to set an amount for you to pay on a monthly basis to try and resolve this. How much money are they trying to get you to pay per month? Have been any discussions?
She asked me to pick a number that I could afford, and I told her $50 a month. It's gonna take me 6 years to pay them back, but that's what I can afford.
Yeah, the $50 a month, the court would not be able to grant any amount lower than that. But again, the way that you approach these kinds of things, I think, is that if $50 is where you are now, then that's where you are. The problem is that these kinds of things have a way of accruing interest going forward. And so you don't want to get in a situation where the number starts going up.
That's what.
So the part that I want you to keep in mind is that if that's all you could pay, then you pay that. But if you get in a position where you can pay a greater amount, then pay a greater amount because that brings you faster towards your conclusion. And
Right.
stems the tide of the interest on it. That's what I want.
Right.
So I'll go ahead and sign the order. I was hoping that it would be that you all could negotiate for some number that was a bit.
Yeah, I was hoping we could too, but.
But I'll sign the order again. You always have the right to petition to come back to court regarding issues regarding collection and stuff like that. Okay. Right. So Ms. Francis, submit the proposed order and I'll sign it and various parts.
Thank you, Your Honor.
All right, ma'am. I wish you well.